We are on the record.
All right, good afternoon, everyone. The appellate court for the state of Connecticut is now open and in session. We will now hear the matter of Villanueva versus Villanueva, docket number AC 43619. I am Judge Mall. I have the pleasure of sitting this afternoon with Judge Cradle and Judge Clark. Because we are still in the midst of a pandemic, we are conducting this hearing virtually using the Microsoft Teams platform. Before I have everyone state their appearances, let me remind everyone that this argument is being live streamed on the Judicial Branch's YouTube channel. Accordingly, to the extent this case involves any protected identifying information that should not be disclosed, counsel are reminded not to disclose such information during arguments. I would now ask that everyone participating in the hearing identify themselves, starting with the judges, then counsel for the appellant, then counsel for the appellee. Again, I am Judge Mall. I'm Judge Cradle.
Judge Clark.
John Hall with Lovejoy and Reimer. We represent the appellant, RAFAEL Villanueva.
Attorney Mark Cratter for the appellee, Mr. Villanueva.
All right, counsel, prior to this argument, you should have received procedural instructions. Do you have any questions regarding those instructions?
No, Your Honor.
No, Your Honor.
Right, a few additional preliminaries when you are not speaking. If you would please remember to silence your microphone, but leave your video on. If you turn your microphone off when you're not speaking, that does assist in avoiding some of that audio feedback that we probably all have become familiar with. Also, let me state the obvious. When you are not speaking, please try to comport yourself as though we were in the physical courtroom so as not to create distractions to the court or opposing counsel. Each side will be permitted 20 minutes of argument. I will endeavor to give you a 2-minute and 1-minute warning. The appellant may reserve a portion of the 20 minutes for rebuttal. Just let me know when you begin if you wish to do so. So, Attorney Hall, are you ready to proceed?
Yes, Your Honor.
All right, you may do so.
Good afternoon, ladies and gentlemen of the court. It's so strange to be in this situation. I would like to reserve 5 minutes for rebuttal, if I may.
All right, that's fine. Go ahead.
I believe this case may appear more convoluted and complex than it is. It was, after all, a one-count complaint. It was filed back in July of 2018. It alleged a unwritten and unspoken implied contract. And I think as the argument proceeds today, you'll understand why that was the count. 4 years had basically passed by the time this case was brought to court after the situation that was sued on. And I think that most of the statute of limitations had passed by that time for breach of contract, oral contract, or conversion or other counts that may have been laid into this complaint. I think Attorney Cratter can be congratulated on finding this statute, which I didn't even know existed, and suing on it. It seemed to be the one branch on which his client's assertions might come to court. Your Honors, this is an interesting situation for me. So it's two brothers. They ran a landscaping and other businesses in the landscaping business together for many years. In 2014, my client, who is the defendant, RAFAEL Villanueva, decided, and this all is in the record, decided that his brother wasn't contributing enough to the landscaping business, which he was in charge of, and decided that time to take the landscaping business and exclude his brother from it. His brother also had a tree business, a masonry business, and later he opened up a paving business. So at that time, there may have been a little bit of a stink at that time, but I think the record shows that, and I think the court found that the parties at that time accepted that situation with something verging on equanimity. At the trial, the court found a partnership existed. The court, if I may step back again, the court found that the unwritten and unspoken implied contract was a partnership agreement between the brothers. And from that finding, basically applied the Uniform Partnership Act to create, kind of flesh out the partnership agreement insofar as he could under the terms of that statute and that act. The problem was there was no written agreement, there was no oral agreement, and in our opinion, there was no agreement at all. We do concede the fact that a partnership had sprouted between the brothers at this time, and that partnership existed at the time of the disassociation. I must note for the court, though, that the plaintiff vehemently denied the existence of any partnership at the trial. And I think that's very important, because I think even if you're going to try to reach into the facts and try to find an unwritten, unspoken, implied contract, you still have to have, and I think the cases support this idea, a meeting of the minds, a shared agreement that everybody involved in the process, we're on the same page, at least to the existence of the agreement. Maybe perhaps not to the terms of the agreement or what might constitute a breach, but at least that the agreement existed. And the plaintiff vehemently denied this. The only agreement he testified to at trial was the existence of an employment agreement with his brother. So I think it's very important that you look at the citations in my brief, which really, they require in this kind of situation. This kind of situation is kind of nebulous in any case. We're talking about an unwritten, unspoken, implied contract. So that's about as nebulous as you get. You try to flesh it out to, if you're the court, to try to find out if something like that existed. But if the plaintiff himself is denying the existence of the agreement found by the court, I find it very difficult to predicate any award to the plaintiff based on that agreement if the plaintiff himself denies the existence of that agreement. They have to find a meeting of the minds. The second thing found by the trial court, which I found interesting, and I'm trying to look up to see if anybody raises their hands, I know this is the protocol, is the idea that by retaining the assets of the landscaping business, the assets of Villanueva Landscaping LLC, when he disassociated himself from his brother, that somehow this resulted in his owing his brother 1/2 of the personalty that was owned by the partnership. I think it's black letter law that the assets of a partnership are those of the partnership, not those of the partners, and it's expressed in the Uniform Partnership Act. And I think that the defendant, in this case, as the member of the LLC that was deeply involved with that particular business, when he disassociated himself from his brother, the LLC retained the assets. The partnership retained the assets. There was no taking from the partnership of the personalty or the assets which was owned by the partnership. They weren't the plaintiffs to be taken away from him. And if he wanted to come back in and claim that, there was some kind of a breach of a fiduciary duty not to do that, that fiduciary duty is a tort, and that had a 3-year statute, and he had to claim that within the statute. The trial court raises the idea of the existence of a fiduciary duty in his decision, but he doesn't take it anywhere, and he can't, because a fiduciary duty is a tort. A breach of a fiduciary duty is a tort, and I think it's important that we keep that in mind. As far as the so what I'm trying to do is I'm trying to search for what the breach was, and I think the court was trying to search for what the breach of the implied, unwritten, nonverbal contract was, and so he finds the contract to have been the partnership between them, but then what was the breach? Was the breach taking from the partnership the assets? No. Was the breach of a fiduciary duty that was owed, which is not a contractual breach? No. So what was the breach? And the court kind of imputes into this situation the idea that the 2014 event, which was an event of disassociation under the UPA, I agree with that, somehow constituted, and he specifically states that it was a de facto winding up and dissolution of the partnership. Well, there is no such thing that is recognized under our Partnership Act as a de facto dissolution and winding up. In fact, when you want to wind up a partnership, or if the partnership is being dissolved, a partner who wants to assert the rights of a partner in a dissolution is obliged to file a statement of dissolution, stating that he no longer has a role in the partnership and the partnership is being dissolved. And nothing like that was ever filed. I guess that would be filed with the Secretary of State. I don't know where you'd file that, but anyway, that's under the Uniform Partnership Act. In addition, I'd like to just return briefly to the way the issue was framed under the complaint. At trial, I think what the plaintiff was testifying to was a conversion. I think under his belief, his brother stole the assets of Villanueva Landscaping from him and converted them to his own use. And in fact, that the language of the complaint infers that. Again, conversion has a 2-year statute, or maybe a 3-year statute, as a tort. It's not a 4-year statute, and it's precluded. And the special defense of statute of limitations was pled to the complaint based on both a conversion and a breach of contract. No breach of fiduciary duty was alleged in the contract, so no special defense was filed with respect to that. But that special defense would have existed had the allegation been pled. So basically, I think in sum, I think this was a situation where the brothers divided the business. They each went their separate ways. And 4 years later, the one brother whose business wasn't doing well, because as stated earlier, his other brother felt that he wasn't working hard enough. He was failing. He came back to try to reclaim part of the part of the business that was successful and that had been retained by the LLC. And that's what this lawsuit is about. And we pled as a special defense laches, but the court didn't seem to feel that the inability for us to bring in witnesses that had been there in 2014, in 2018, had enough prejudicial effect against the plaintiff to merit that special defense being imposed. I don't think I have anything else to say at this time, so I guess I'll cede the floor to Attorney Cratter, unless your honors have any questions.
All right, seeing none. Attorney Hall, thank you. If you would just mute yourself, and we'll turn now to Attorney Cratter, who will have 20 minutes. Attorney Cratter, you may proceed.
May it please the court. My name is Attorney Mark Cratter. I represent the appellee. We ask that the court affirm the decision. In the beginning, as stated in the opinion, it was more of an employment contract. Over time, that morphed into a partnership between the two parties. At first, in 2005, my client started the business. In 2007, my client's brother, the appellant, joined the business as an employee. Over time, they started sharing more of the duties together, and they started dividing up the duties of the landscaping business. In 2011, the defendant, appellant, formed an LLC, naming himself as the only member. Basically, they worked as partners. They shared the profits. They split up the work. And one day in 2014, the defendant decided that he was going to take the landscaping business. That landscaping business belonged to my client 50%. I believe in the testimony, he testified that my client was a 50% owner. So what we sued for was the value of the business as my client saw it. When my client formed the business early on, about 4 years later, they purchased a list of customers for a price, and each customer had a certain value. Both parties testified as to the value. My client testified that each customer on the customer list was worth $1,500. The defendant testified 800 to 1,000. That gave the trial court the ability to determine damages insofar as what the customer list was worth. My client also viewed the value of the company as the equipment, what was owned by the company itself. And we had listed a lot of equipment, all the equipment in the complaint itself. And then we went to trial, and my client testified as to what he thought the value of that equipment was. In the brief, the appellant states that they did not have the advance notice, but they did. It was in the complaint. They could have also done discovery, discovered what equipment we claimed belonged half to my client. They didn't do that. So I don't think they can make that argument. So what we see here is basically a partnership between two parties, a breach of the partnership agreement, the implied partnership agreement when the taking took place, when the appellant took the business to be his own, when he took the equipment to be his own, that's the breach. That's what we claim the breach to be. So for all the reasons I'm stating, I'd like to ask that the court affirm the decision, and we rest on our brief. Thank you.
All right, Attorney Crowder, let me just ask you a question. So when in argument before Judge Kremich, was it your position that your client was entitled to 50% of the equipment that you alleged that the defendant took in 2014? Or was it your position that your client was entitled to 100% of it under an employment contract theory?
It was our position that he was entitled to 100%. That was my client's belief, that it was a relationship of employer and employee. However, the court found that it was a partnership agreement because of the facts that were testified to, which basically from the beginning, I believe the decision says it was an employee-employer relationship. But when they started sharing duties, they started sharing the banking, they started sharing the profits. They bought in the profits, which they shared 50-50. That was used as evidence that it was 50-50. So it was my client's position of 100%, but the court found 50-50.
All right, thank you. All right, seeing no other questions from my colleagues, we'll now, unless Attorney Crowder, you have anything else, we'll turn now to Attorney Hall.
No, Your Honor, thank you.
All right, if you would kindly then just mute yourself. Thank you. All right, Attorney Hall, you have about 8 minutes on rebuttal.
Thank you, Your Honor. I don't think I'll need all that time. I believe Attorney Crowder's characterization of the case is more or less accurate. I also believe that when he says that the lawsuit related to the defendant taking the equipment, taking the business, I think that once again runs back to conversion. I think perhaps the trial court felt that what had happened here was unfair to the plaintiff, and, found that this partnership agreement, which I believe did exist. I think they were partners, and I believe they were 50-50 partners, was somehow implicated. But I don't think the partnership argument can save the claim. I think that the UPA is about as thorough as you can get on defining what the rights and obligations and duties of partners, and it kind of fills in the gaps when they don't have their own written agreement, which is something we all have to deal with in private practice. And oftentimes partnership relationships can develop as they did in this case, certainly between brothers. And I think the testimony at the trial indicated that, the brothers were working together. Rafael, the defendant, seemed to be the brains of the organization initially. And the reason he set up the LLC is because they hadn't set up an LLC. It wasn't like to try to, defraud his brother out of anything. They needed to create an LLC. They needed to get a bank account. They needed to be professional in their engagement with clients and their way of doing business. And it hadn't been that way before. So he set it up. He ran that part of the business. And, I think that one of the really important quotes, I think, from the decision that I'd like to note for this panel, once I find the decision. Here we go. No, that's not the decision. Sorry. Oh, here we go. Is the footnote that the court places on page 7. It's footnote number 8. And it says, each partner accepted the de facto dissolution and winding down that occurred in 2014 and conducted their respective businesses separately since then. I mean, this is really determinative of the fact that there were two aspects to the business, and that each partner accepted the post-2014, if not with equanimity, at least, accepted it and continued to do business with their respective roles. And it wasn't until 4 years later that the plaintiff decided he wanted to sue his brother because he was failing. And I just don't think I think we have statute of limitations in place. I think if you're trying to apply this statute, which is a very odd statute that allows you to sue in 6 years. So, I mean, even if you have a written contract, you only get as good a statute of limitations as you get if you have an unwritten, unspoken, implied contract. So I think the statute has to be viewed in the context of all our statute of limitations, all our other causes of action, all our relationships between parties in what it is trying to achieve. And it's trying to achieve a situation where there was a clear meeting of the minds, clear agreement as to what was agreed to, clear, and even though it was unwritten, unspoken, and implied, at least you can determine that the parties agreed. They didn't agree here. I mean, there's no evidence that they agreed. The evidence is exactly contrary. The plaintiff viewed my guy as an employee. My guy viewed himself as a partner. The court went with our testimony on the partnership existence, and then, went ahead and decided in the plaintiff's favor on what was going to happen because of that. And I think for the court and the plaintiff to avail themselves of the Uniform Partnership Act, which is the only thing they can, you have to look at the act. And I don't think the act supports the idea that there can be a de facto winding up. A dissolution and a winding up is a formal process. And if you look at that decision in Baghdadi, it's an unreported decision by the federal court, but it's very illustrative of what I'm talking about. They go into the fact that under the UPA, you cannot just sue to get the assets back as a partner. The partnership owns the assets. If you want to get them back, you have to bring an action to wind up or dissolve. And it goes to a situation just like this where there was a disassociated partner. It really is on all fours with this situation, and the proper method for achieving his goal of getting a dissolution and the attendant winding up was to file the statement and to start the process. And he didn't do that. Instead, he's suing under tort theories or contract theories that aren't contract theories. And I don't believe it was fair, equitable, or legally valid the way the court decided the ultimate issues in this case. The subordinate facts, I don't necessarily disagree with all of them, but the ultimate resolution of the issue was not, I don't think, properly applied under our law.
All right, thank you, counsel. I see no questions from my colleagues, so the court will take the matter under advisement. Thank you for participating in this virtual setting. We look forward to being in the physical courtroom next month, at least at the appellate court. So I wish you well. Again, the court will take the matter under advisement. This is the last case of the 7th term. The court stands adjourned until the 8th term. Thank you.
Thank you, Your Honors.